Well, hello and welcome back to my channel. Well, I've just sat through another court hearing. Still a little bit jumbled, so I apologise, but I'll tell you what we know because there was a lot of to and froing. So first of all, His Honour gave down his verdict about parliamentary privilege. Essentially, he has deemed that the defence of parliamentary privilege cannot be used. You cannot use the defence that it was seen in Parliament. Some of his reasons was that it was well scripted and well thought out, and the video was done in such a way that he felt that he could use parliamentary privilege to hide behind, and if he allowed that defence, then there could be other publishers that would really would hide behind parliamentary privilege. He also stated that Barilaro can't decide what's parliamentary privilege. That's up to the Parliament. And if Shanks wanted to get permission, he would need to approach the Parliament. He did state that based on that, and that was a lot of the defence of Shanks, and that was what they said at the interlocutory hearing, in the interest of justice, that Shanks would have to refile another defence. He had to outline the defence for each of the facts, and he had to define which fact was personal privilege, personal opinion, and what fact was qualified privilege, and that had to be outlined properly. He also ordered that Shanks pays the costs of Barilaro for the last hearing. So that was the last court hearing, and remember that went for a whole day. So there's a whole day worth of court costs there. Now, Google also appeared, or their lawyers appeared for them. They've already said that they're going to use qualified opinion as their defence. They also support the jury trial that Shanks has asked for. And so Google and Shanks have until the 25th of August. Google and Shanks have until the 25th of August to file defences. So Google hasn't filed a defence. Shanks is refiling the defence. Bruz has until the 30th of August to respond. So they're limited to 5 pages, their defence. Bruz has to respond on 2 pages. They have to give a list of authorities they're going to rely on in their pleadings. There's also been an order made for an outline of submissions because His Honour had said it's very unusual for a civil trial to have a jury, and the implications and the work to have a jury trial sit is going to be hard. So he doesn't want the court delayed any further than what it has to be, because there will be delays as they work out how to do the jury trial, particularly if it has to be online. So he wants submissions and all of that outlines by the 25th of September. Google has already said that they did ask for more time. It got rejected because apparently they're a large company, but they are prepared to show technological evidence and technological analytics and everything if required as part of the defence. So that's the long and the short of it. So the parliamentary privilege aspect was declined as part of the defence. Therefore, the defence has to be rewritten. Shanks has to pay the costs of Bruz for the last hearing. Google has to file a defence. They haven't had that opportunity, so they're filing their defence. And they're back in court on the 31st of August to do it all again. And I hope to be able to bring you all of that as it plays out. So until next time, I'll catch you again soon.